Well, Donald Trump is expected to speak later on this morning after he was found guilty of 34 counts in his criminal hush money trial. The presumptive Republican nominee is the first former president to be tried and convicted of a crime, and he's set to be sentenced July 11th. So for more analysis, we want to bring in Tom Dupree Jr. He is the former Deputy Assistant Attorney General and represented George W. Bush in the Bush v. Gore Supreme Court election case. Thank you so much for joining us. All right, let us dig into this. Before reaching their verdict, the jury asked to have certain portions of testimony and instructions read back to them, including a portion about how conclusions can be inferred. What was the connection that you think the jurors were trying to reach based on what they asked to be repeated?
Right. Well, it's always a challenge trying to infer what the jury was thinking based on the questions that they asked the judge. But in this case, I think it does seem like the jury basically wanted to know how, in a legal sense, it should think about the evidence. It's not that unusual for juries to ask to hear witness testimony read back. It's not that unusual for juries to ask to get the jury instructions read back to them. But in this case, it appears, based on the evidence they asked to hear again, based on the jury instructions they wanted to hear again, that they were honestly just wrestling with how they should think about evidence and whether it was okay for them to draw certain conclusions from particular types of evidence, whether they could use evidence to draw inferences or otherwise use that evidence to reach their verdict.
So let me ask you, if you could ask a member of the jury a question, what would you want to know?
Oh my gosh, where to begin? I guess the first question I would probably ask is to say whether there was really any significant debate or dispute about his guilt. I mean, from my perspective, this deliberation occurred pretty darn quickly, just given the length of the case, given the complexity of the case. And given the fact that they had 34 charges to resolve, that they returned a verdict in about 2 days, which is not lightning fast, but still is pretty fast. So I would just be interested to understand where the jury began its deliberations, if there were some jurors who actually were pushing hard for an acquittal or at least expressed uncertainty about the right result, or if it was the sort of situation where the jurors all came in, they said, we all think he's guilty, but we just want to kick the tires a little bit on our conclusion before we render the verdict.
So, as you know, Michael Cohen was described as one of the star witnesses. And, Trump's defense really focused an awful lot on whether or not Michael Cohen was trustworthy or, their assertion that he wasn't trustworthy at all. I want to play some sound from Todd Blanche, Donald Trump's attorney, talking about the verdict and Cohen's role.
I think that at the end of the day, it remains true that if the word of Michael Cohen was not accepted at all, then you could not have convicted President Trump, and the jury convicted.
So I'm curious about your take on this because, we were talking yesterday, and when you have a case that's kind of like a conspiracy, pretty much everyone involved has their hands dirty to a certain degree. I would think the jury would take all of that into account. But what's your take? Do you agree or disagree on whether or not Cohen's believability was important in this case?
My sense here is that I think Cohen's believability was important to this case. But I think the jury probably said, look, regardless of what we think about Michael Cohen, there was other evidence in the record that supported a finding of guilty. That's the way that the prosecutors teed up this case. They knew going in that Cohen was potentially their Achilles heel. And that's why they told the jury that you don't have to take Michael Cohen's word at 100% in order to render a guilty verdict, because we're going to prove our case to you by way of evidence, by way of testimony from other witnesses and the like. And I suspect that's the way the jury came down. I can't imagine that there's anyone on the jury who at least didn't harbor some doubt about Michael Cohen's credibility. But my best guess, based on what they ultimately decided, was that they were able to put those doubts aside, look to other evidence in the record to render the findings that they did.
So the expectation is that Donald Trump and his attorneys are going to appeal. I imagine there are a number of ways that they could do this. Give me your top 2 or 3.
Oh gosh, let's see. I think my top two or three would be number one. I would probably focus on the jury instructions, which is a common way to challenge criminal convictions. If the appeals court were to find that the jury was improperly instructed on the law, that typically would be a basis for throwing out the verdict. Another thing they could look at is the judge's rulings on admitting or excluding evidence. You'll recall the judge pretty much restricted the expert evidence that President Trump wanted to put on in his defense. You'll also recall that the New York appeals courts recently reversed Harvey Weinstein's conviction because, in their view, the judge made improper, incorrect evidentiary rulings. I suspect the Trump team is also going to go after the bias and the alleged corruption of the trial judge, although, to my sense, I don't think that's a particularly promising line of attack. I suspect the Trump team would be better off focusing on things like jury instructions and evidentiary rulings.
All right, Tom Dupree Jr., pleasure talking to you. Thank you.
Likewise. Thanks, Anne Marie.